Hi, Lucian. Thank you so much for doing this interview with me today. Lucian, I wanted to start by talking about your career path. So you practice investment arbitration and you are a qualified lawyer in multiple countries and you are a barrister in the UK. Could you please share your journey from starting as an associate and to becoming a barrister?
Sure. Thank you. Thank you so much, Valeria, for your kind invitation and for having me. It's really a great pleasure to have this chat over my career, over the barrister role, and overall of what are the opportunities there for international arbitration lawyers. So first of all, I would like to start with my academic experience, which led to my, multiple qualification, as you just mentioned. So I started in France, and I have what they call a double diplôme in civil law and common law, where I had graduated from Toulouse University in the south of France and Dublin, University College Dublin. So I did the first 2 years in Toulouse, and then I spent the third year abroad in Dublin. And then I had qualified for an LLM and passed an LLM in international arbitration at Queen Mary University. They have this, School of International Arbitration in London and Paris. So that is, my postgraduate degree. So this dual education allowed me to become a member of the Paris and Bucharest bars, where I worked from 2013 until 2018, and then to become a solicitor advocate and the barristers in England and Wales in 2018. And then lately to be admitted to practice in the UAE, in the offshore countries, such as the ADGM in Abu Dhabi and the DIFC courts in Dubai. So this is very easily manageable when you are qualified in England and Wales. You have a very straightforward route. So that are my last, I would say, admissions as a lawyer. Now, if I may start back in my career just to explain why and how I arrived in international arbitration arena. So back in time in 2013, I started my career at McDermott, Will & Emery in Paris in 2013. And at that time, I was working with another barrister, Jacob Christen, who gave me the appetite for doing investment arbitration work. I was involved in that time on a big investment arbitration claim, which was in French, which is surprising because very few cases that are in French in ICSID. And that was a landing against Tunisia. And I remember being with Jacob, hands-on on the case. I was involved in the drafting the submissions and attending the hearing. And very quickly, I knew that, I want to do that kind of work. And it's why I just moved right after to the arbitration boutique Lazarev Bars, just to focus on those kind of cases. So for a long period of time, my practice covered 80% investment arbitration work and some 20% commercial arbitration work. So if I need to mention which were the key decisions of my academic and professional career, who brought and made me the lawyer as I am today, I think there are three main, I would say, experiences which really shape the path as of today. So the first one, and I think it's a very important one, is my experience abroad at University College Dublin. Because before that time, I wanted to be a public prosecutor. My family was involved in high level, public officials in Romania, Bucharest, and I grew up within that kind of framework. And yes, I wanted to do the same more or less. And then when I moved abroad and I discovered courses such as international law, EU law, conflict of law, jurisdiction, I just wanted to do this kind of work, and law. So that was the first, I would say, decisive factor in me becoming an international lawyer. The second one is when I moved to London early 2018. So back in time, I was with Lazarev Bars, working as an associate. And unfortunately, the firm was experiencing some financial difficulties, which prompted most of the 10 lawyers to look for opportunities elsewhere. So what is the takeaway from this? Sometimes a difficult situation in life can, in fact, be a career opportunity, without knowing. Of course, back in time was not a good time, and everyone was more or less stressed. But when I look back in time, I would say nothing happens without a reason in life, and at that stage, I was, and again, another coincidence is that at that stage, I was freshly admitted as a solicitor in England and Wales in December 2027, and those financial issues started early 2018. So you see that the timing was perfect for me, and of course, back in time, I didn't know that was going to happen. It was purely, a decision that I took to become also a solicitor in England and Wales, because I had this dual degree. I was qualified in civil law and trained in common law. So for me, the natural choice was also to work in common law, not only to have a degree. So back in time, I just applied to London, and in 2 months' time, I had an offer from the international arbitration team of Freshfields of Reed Smith in London, and I decided to move to London with all my family, and it was a really great decision, which I did. And the third, and I think the best recent decision of my career is my decision to move to the UK bar in 2020, which is a very competitive role, but at the same time, a very rewarding position and role.
How do you even qualify to join the bar? Can you explain how it works, how the system of chambers works in the UK?
Sure. So I think there are a couple of paths that you can qualify. Of course, you have the traditional route where you do your law degree. You are part of one of the 4 INS, which are at those schools which are training barristers and calling the barristers at the bar. So there are 4 in London. I'm part of the Inner Temple Inn, but there are other 3, Middle Temple, Lincoln's Inn, and Gray's Inn. Those 4 schools are equal. There is no prestige over one or the other. There is no, I'll say, list or ranking, if I may say. What is the difference, perhaps, is the culture and the approach, and I would say the whether it's more international or whether it's more focused on a specific practice or another. So those are the considerations, but there is no ranking or which one is better than the other one. So I picked up Inner Temple because they are very focused on international profiles. So I am, of course, an international lawyer. So I think that corresponded to my profile very well. And I'm very happy that I chose in the past that. So traditionally, one needs to spend 1 year doing what they call vocational training, and then have a second year, which is called the professional path, which is the pupillage. But in my case, I took a very different path, because at that stage I had 10 years experience in the private practice. I was, some 5 years in Paris, 5 years in London. So I qualified in London as what they call solicitor advocates. So those are the solicitors which have high rights of audience. So a barrister is what it is. It's an individual, a lawyer who has high rights, i.e. the rights to appear before a local judge in court. So I had already those rights. So my transfer to the bar, it is called, was quite straightforward, because you have just to do a very quick training of 3 months, and then another training once you are at the school of three months. So in short, in 6 months, you are trained, and you can become a barrister. Now, perhaps say why I moved to the bar, because I think that is important. And what I've seen, there is a tendency of solicitors or international arbitration lawyers which are aiming to move to the bar. And in my case, at least, while I had a very great and wonderful experience with all the firms that I worked with, I think you arrive at one stage after 10 years where you are just at the level of counsel or in the past to become a partner. So at that stage, you are focusing less with the legal work and more on management, task. And in big international law firms, you have other considerations such as conflicts. For instance, this very often prevented me from accepting arbitrator appointments. The second hurdle for me was the pricing. In US firms or UK firms, you have always high hourly rates. And therefore, when you are competing for pitches with other, smaller firms or boutiques, you never get the work because you are too expensive for that.
In most cases, because of that.
Indeed.
Probably difficult to win the competition if you bill over £1,000 per hour.
Indeed. And this is the case, back in time I was, I don't know, £700 an hour. And I was only, a senior associate, and the partners were around £1,000 an hour. So it's very, very hard to get work. The third hurdle that I had again in my case was the lack of advocacy, because UK firms traditionally, even though we are, in the arbitration arena and no one needs, a higher rise of audience, in practice, they are used to instruct barristers, and the clients are expecting to have a barrister on board, whether it's traditional litigation or international arbitration proceedings. So that was a third hurdle. And perhaps the fourth one is that it's very difficult to divert your practice because, as you know very well, international firms are divided by specialized teams or departments. So you are part of, I don't know, a team, whether it's arbitration, whether it's litigation, whether it's investment arbitration, whether it's commercial arbitration. So once that you are part of that team, it's very hard to have a wider picture and experience. So those were the four considerations that, pushed me to move to the bar. And that was really, really interesting because it shaped my, my profile. It gave me the tools. It gave me the all the background that I needed and the training that I needed. And it's why I decided then to do the step and move to the bar. But I must confess that while the academic transfer, the regulatory part of the transfer was quite easy. Yeah, it's not something hard. It's not like, in France where we have to do the Article 100 or whatever, the equivalent. This was quite easy, I must confess it was quite easy. But what was very challenging, and this is something really, really hard, and to be frank, I was not expecting, I throughout all my career, I always, studied, I always had good grades and working, in very competitive and leading practices. But the bar is something very unique and very challenging. For instance, in order to get a tenancy position, or perhaps if you are a younger or a less experienced lawyer, pupillage, you need to do at least 3 main steps. And those steps are, of course, eliminatory. If you don't manage to pass the first one, you don't go to the second round, and you don't go further to the third round. So without spending too much time, I'm just gonna summarize the 3 steps. So there is a first step, and of course you're gonna apply, and you send your application a standard with a CV, a letter, a covering letter, and 3 references and as well some proof of your work, written work. So the first interview is very challenging and competitive because you are receiving within 48 hours before the interview some 500, 700 pages in a bundle, and you have 24 hours to prepare a skeleton argument of maximum 10 pages. And it's like in court, it's literally what is happening in court. So you have 24 hours to prepare a 10-page skeleton, and you send to the committee. That is the first part, and they are analyzing your written skills. And if you are, passing that stage, then you move to the second part, which is what they call the oral part, or the oral advocacy part. And during that part, you spend half an hour pleading the legal matter that you prepared, but also another half an hour in replying to diverse questions asked by a panel, a recruitment panel, which is very often composed of 2 or 3 cases, King's Counsel, senior barristers, and 2, 3 juniors. So you are in front of a very, very powerful panel with a lot of experience, and they are asking questions. Can be on your practice, can be on the case that you worked on, but also can be on different areas. I had questions, if I remember well, about landlord and tenancy.
Okay,
I never did that before.
Investment arbitration.
Yeah, I specialize in investment arbitration, and then you have to switch to a tenancy contract. I like, wait a second. But anyway, that was very, very constructive, and this allowed me, thankfully, to move to the last part of the interview, which is the third part, which is what we call the business plan. And the business plan is quite different because the competitive process and the chamber system is very different, and it's why it's very important to have a very compelling business plan. You need to show what are your plans and what is your business case for the next 5 years, because chambers are different than law firms. You are not employed anymore, and you are not perceiving a salary anymore. It's the other way around. You are bringing money to the chambers, and you are paying the chambers. So if you don't have a successful caseload and profile, no one gonna have appetite for your profile, because you lose money. The chambers are, sets are called also sets, are groups of self-employed barristers who work under the same roof. And therefore the places or the rooms are limited, So if one gives you the room and you don't bring money, they're gonna lose money on each.
Fascinating. So there's a finite amount of barristers in the UK, right? In each chamber.
It's a very, very high demand, but while the demand is high, the competition is very, very competitive, because the issue is that perhaps only 10% of the lawyers are barristers, more or less, whereas the 90% of the other lawyers are solicitors. So when you look to the ratio barrister-solicitor, you can see very quickly that, the barristers are much fewer than the solicitors. But those places are very, hard to get. And perhaps what was the most challenging for me was that while I was, expecting to be hard, I didn't know that chambers have a very, very traditional mindset. In the mindset of the chambers is that they are looking for very similar profiles. 80% of the chambers, they are looking for lawyers which are Oxford or Cambridge, and they are looking for candidates which have distinction. I.e., you need to be the best in your class. But then you need also to be, I would say, multi-sectorial. You cannot have one practice. It's as I was expected to do when I was in a law firm. You are in a department and you are doing one single expertise and that's it. No, barristers, it's not like that. A barrister will need to have at least 3 main practices, 3 main areas. Mine is international arbitration, commercial litigation, and I'm doing also arbitrator work. So you need to bring 3 offers on the table, because this keeps you busy always. And for instance, if you are a shortage in the arbitration work, then you take some court cases and you go in court. So this allows you to be fully busy every day. Now, I don't know if you know how the sets are working, but in short, the chambers are typically run as unincorporated associations. The barristers within chambers are independent practitioners who contribute to the shared expenses, but operate their own practices independently. So chambers are managed by clerks, by administrative staff who support the barristers by securing work, managing diaries, handling billing, and providing other logistical support. Now, in exchange, we are providing, as I said, a levy, a contribution, which contribution is usually between 15 to 20% on average of our annual income. We're gonna pay for those, room, facility, clerking, marketing, logistics, IT, billing, etc. So one needs to know that you have those expenses and you need to pay those amounts. Because, to be frank, myself, in my case, I would have been very, very scared if I were to start from day one with no experience as a barrister. I took a different path. I took what they call the transfer to the bar. I was a lateral move. Yeah? I moved from the solicitor, from the lawyer work to the bar, and I brought 10 years experience. So at that stage, I was less stressed because I knew people, people have seen me in practice. They worked with me. They knew how reliable I was. So I knew that work was going to come from the pipeline, and the colleagues that knew me. However, I'm always thinking how the junior barristers are coping, because, you start and then you have to build up your practice and your, profile from scratch, from zero. So it's very, very challenging.
But it's actually very interesting what you're saying, and this whole idea about having a business plan, and this whole idea that you brought with you 10 years of experience when you started, but you also brought your network of your connections who give you some work in the beginning to help you get started as a barrister. Can you tell us a bit more about your client acquisition? So, as a barrister, you're not affiliated with one particular law firm. So how do you get new clients? How do you get work?
So that is a very interesting question, because the clients are not anymore the lay clients, as it was the case before. But my clients are now my friends, my colleagues, my lawyers' friends, and that is something interesting approach. So the most common way for barristers to acquire clients is through referrals, instruction from the solicitors. So the solicitors are acting as a primary point of contact between the barrister and the lay client, and they are preparing the cases, and then they are instructing a barrister for advocacy, for specialist advice, or other complex legal skills. So the first client target is to build a reputation among the solicitor. It means that a barrister has to have the ability to maintain strong relationship with the lawyers, as they are the key source of the repeat work. So if I have to put a number, I would say that 70% of the work is coming through this route. The lawyers instructing me because they know me and they've seen me in the past, because my reputation, because my expertise in the arbitration, and that I would say that is the main channel of the work. The second channel and the second way of acquiring clients is via the clerking. So the clerks are staff member which are working for you. You are paying them, of course, via the levy that I mentioned earlier, and they are here to assist you, to support you. And very often, in addition to handling your agenda or preparing the bundles or helping you with any diary or logistical task, they're having also a network. Yeah, they go on the market. There are some agents, if I can say, they are representing you on the market. So they are attending events, doing business networking, and when they are meeting potential new clients, they are sharing my profile, but my colleague's profile as well, depending on the opportunity. So a good tip and a good advice: be always kind with all the stuff, I would say, but in particular with your clerks, because if you are having a very good clerking team, you might have a lot of work and additional work, I would say, from their network. Now, that is what I say, 20% of the addition workload. So the remaining 10%, is the exception, I would say. Because under the UK BSB, the Bar Standard Board scheme, there is another route which is called public access. So public access means that lay clients, i.e. not solicitor, the lay clients, the ultimate client, can directly approach a barrister without the need to have a solicitor in the middle, in between. And this scheme is, however, available only for trained barristers, which had a specific training in managing clients and the quality and the capacity to conduct litigation. Yeah, usually the conduct litigation is done by the solicitor, and the barrister is coming at a later stage at the party. So with this public access scheme, it allows you to go directly to a barrister, which means what? It means that you may have lower costs, yeah, because you will not pay a solicitor and the barrister at the same time. You have a barrister who is doing alone all the task. However, I must confess that while I'm also a public access barrister, because I'm a former solicitor advocate, so I'm entitled to represent clients as well, I must confess that there are limits to this scheme. Because when you are a barrister, you are involved with a lot of legal work. And you don't have the logistical support that a law firm has. So for me, for instance, I'm very rarely accepting to work on public access. And public access doesn't mean, just to be clear, doesn't mean legal aid. Yeah, it's not for people which don't have money and they have public access. This is a different thing. Yeah, no, it's not like legal aid. It's just direct access to a barrister. That it means direct access scheme. So the issue is that when you are alone and you don't have, stagiaire, interns, paralegals, and all this, a team that supports a lawyer in a law firm, it's very hard for me to do both and to be everywhere. I cannot do the binders. I cannot do the proofreading. I cannot speak the phone with the client at the same time, preparing witness statement at the same time, but then be at the same time in court. So this is very challenging. So it has its own limit, I would say, Valeria, the public access scheme.
That's super interesting. And if we maybe go back to the first channel, that is the main channel through which you get work, so other solicitors, it probably means that you need to always remain, top of mind among your friends, your peers, other solicitors who, when they have a case, they will give it to you and not to someone else. So what actions do you do to maintain your market visibility as a barrister?
Yeah, so there are several, I would say, approaches that one could take. Because as you mentioned, I think the profile is much more important than in a law firm. In a law firm, you have the law firm. That is the brand, yeah? The law firm is a brand. I'm going to, Clifford Chance or Freshfield because I know they are top tier. With chambers, it's different. Don't go for a chambers because of the name, because a chamber doesn't really mean anything. It's the barrister behind it, which is the brand. So the first recommendation would be to build a strong reputation with the solicitor by, for instance, what I'm doing very often, I am doing some in-house trainings, either brunch, breakfast, lunch. I'm going there for 1 hour because 1 hour at the breakfast or the lunchtime, it's a dead time anyway for lawyers, So my approach is to go there, spend 1 hour time with them, pick up a practical topic on which they would like them to focus on, or on which they are working, for instance, and then I can bring my training for them. And during this 1 hour, I'm giving a presentation on a Greek topic, but then we exchange on different legal issues. So that it allows me not only to maintain my relationship with the lawyers, but also, I will say the most important, to show them that you are a respected authority in the field, that you know what you are thinking about, that you are, an expert in your area. I think that is very important. Now, the second advice that I will give, and I think it's also linked to the first one, is a good barrister is also recommended to have a niche practice. Now, while you have some general practices I mentioned, can do some, court litigation and commercial litigation in court, I think you need to have one main core practice. You need to be known for something in your field. For instance, I'm very well known in London and abroad for my public international law experience and international arbitration. So at the bar, we are very few having this profile. So when you have that profile, you need to shape it. You need to keep it updated. And how you do it? Traditional work, publishing articles, lectures, public appearances in a specialized topic. You need to have visibility and show that you are a specialized barrister in your field. Now, the third approach that you need to use as a platform is the Chamber's website. A well-maintained Chamber website with a detailed barrister profile is mandatory. You need to have your recent cases updated every month, whether it's the words, publication, and the years of expertise that you have. And you need to show what are your key practice and what are your recognition. Because very often a solicitor, and I remember me doing this in the past when I was at Smith, spends not more than 1 minute when they are looking for a barrister. So in 1 minute on the website, they need to know very quickly if you are the right person for them. If they don't see that from a very, instant, spending, 30 seconds on your profile, they're going to move to another person. So it's a very competitive practice. So you need to be sure that your main, attributions and qualities are shown very quickly on the website. So the website is very, very important. Now, another marketing tool that barristers are using is leveraging the legal directories. The legal directories such as Chambers and Partners, Legal 500. Those are very, very important. And by the way, this week we have the submissions for Chambers and Partners. So the barristers are spending time. It's not like anymore in a law firm where you have the marketing team doing that, or legal advisors, such externals which are preparing and doing your marketing for you. No, when you are a barrister, you are doing this. So you take the submission from the Chambers and Partners, and you are putting your and building up your profile just to be sure that you are recognized, because those rankings are very important for solicitor and lay client as well. And additional tips would be standard tips such as use of social media. The platforms such as the LinkedIn is always an excellent choice. It allows you to raise profile, to share insights on recent legal developments, and demonstrate that you have an expertise in a specific area of law. Now, for barristers, what is an additional tip, which is not really the case for traditional lawyers or solicitor, is the networking and the professional associations. Now, for the barristers, we have what we call the professional associations, such as the ComBar. The ComBar is the Commercial Bar Association, which allows barristers to build in and be part of an association for networking opportunities and collaboration. This is the first tip. The second one is to be appointed to the Attorney General ABC panel list. What are those panelists? Those are the panelists for experienced, mid-level, and junior. A, experienced, B, mid-level, and C, junior barristers, which allow you to be instructed for government work. So the government picks up their barrister not via traditional pitches or networking or whatsoever. No, the government via the Attorney General only extracts lawyer from the panelist. So in order to be a panelist, you need to apply to be selected. It's very competitive. However, the downside with the panelist is that the hourly rates are very, very low. So on the one hand, it allows you to have exposure to very, very interesting cases working on government work. But the downside is that it's more an investment for the barrister, because the hourly rates are 3 times less than the standard hourly rates as one would do in the standard, practice as a barrister.
That's super interesting. Thank you for sharing so many tips about building your personal brand as a barrister, and exploring different channels for finding clients, for finding new cases, for finding new work. That's fascinating, and I think it's very, very new and very different, from traditional French market.
What I think is interesting is the challenging and rewards, because that for me was very scary, because you are moving for something that you are comfortable, you are in a salary partnership, and the work is coming easily, and you are paid every month whether you are doing work or not, because how it goes, it can go up and down. But that doesn't work like that for a barrister. So perhaps touch bases on a bit on the challenges and the rewards. I think it might be a very, very good feedback for those which are interested to move to the bar.
How was it for you? Because you were working in top law firms in Paris, and then in London. And as you said, in a law firm with 10 years of experience, you're in a comfortable position. You know that you will have work, and if you don't have work, well, you have time to adjust. To either get work or move to another law firm. And then also, well, I know that you have a family and you have kids, and it is a responsibility, for you to organize this lifestyle of your family in London. How did you navigate this, from being in this comfortable position to decide to becoming on your own, in a way?
No, I think that was the hardest part, Valeria, to be frank, because it took me 1 year to reflect on it. At that time I was in the process of applying to become counsel in my prior law firm at Smith. After 10 years, usually you are becoming counsel and then partner. Yeah. So at that stage, I was thinking, am I in the right place? And I mentioned earlier the hurdles that I had, but at the same time, I said, it's not all about the money. It's not all about being in a very comfortable place. I always like challenges. Mm-hmm. I think the short answer is, if you don't risk it, you don't get the rewards, and I think this applies for any activity. It's not only for lawyers, So the first issue was, of course, the financial part, mm-hmm. because when you start as a barrister, you are self-employed, and the time that you are moving to the bar, that you are instructing, mm-hmm. that you are working on a case, and then that you are billing the work that you have done, it can lapse at least 3 months time. So that for the first 3 months time, you will not have any revenue.
Yeah.
And this is what happened, But luckily for me, I got work from day one. Mm-hmm. From day one, I worked with my former colleagues from McDermott and Emery. Mm-hmm. And I've been brought in a big exit case against Romania, my own country. So it allowed me to, I would say, overcome this financial hurdle. So I don't know if it's luck or because, I had those 10 years experience, and someone in my shoes will have the same, luck, if I may say. But that helped me a lot. Now, something different, in addition to the financial part, is the pressure and the responsibility.
Of course.
Because you are not working anymore as part of a team. Mm-hmm. So you don't have anyone that will going to review your work, as was the case with my partners in the past. Now you do the final work product and you sign it yourself. Mm-hmm. And when you send it to the client, you don't send it to the lay client, because the lay client might not to know what you are saying. You send your work to the solicitor client.
Yeah.
The solicitor client has the same background like you. And if you are saying something stupid, they will know very quickly. So that is a pressure, I would say, an additional responsibility, which a traditional solicitor is not used with that. A third challenge, I would say, is the long and unpredictable hours. In a law firm, you know from the very beginning that you are working on 1, 2, 3 cases, and you know who is working on that case with you, and you have an estimate on when the deadlines are, and you know when will be a busy month or a less busy month. Doesn't apply for barrister. Barristers are receiving instruction on a daily basis. So today I may be asked to go in 2 days in the High Court. I'm receiving a bundle. I need to prepare a skeleton, and then I'm going to go to plead it. So we work by tranches. We are accepting instruction. It could be a short instruction, 2-3 days, long instruction, 1 week work, or even longer instruction for 1 month where we prepare for a long trial. So you know that during that time frame, you block your agenda for one specific client, and that's it. And you spend hours and hours for 2, 3, 4 days or whatever. So it's very different workload and the type of work when compared to the traditional solicitor. Now, additional hurdle and challenges might be the career progression. Because, you know, in a law firm, you know how it works. Junior, mid-level, senior, associate, counsel, partner. That's it, you know. And it's straightforward. At the bar, it's much, much competitive because you are junior or senior. Juniors are, I don't know, perhaps 85% of the barristers. And the senior, which are called King's Counsel, before was the Queen Counsel, are very, very few. And it's very, very hard and challenging to become a KC. Or a UK judge, the same, you know, like in England, you don't have, as in France or Romania, you don't have magistrates, which are trained from the very beginning. In England, the UK judges are former or current full-time barrister. So it's much harder than one would expect. Sorry, you were saying?
No, I was asking if you are KC.
I am not a KC. No, I'm not a KC. So a KC, usually you need at least 15 years as a barrister to become a KC in practice. So it's very, very hard. You apply, and in practice you apply 3 or 4 times before being, you know, successful. And you know, it's a long journey. It's a long journey, and for me, you know, it's a long track. To be frank, I don't know whether this will be something for me. I'm just fresh at the bar. You know, I've been for 3 years now. But clearly, this is something that needs to be considered and prepared in due course with, you know, with skills and colleagues supporting you, judges also from the judiciary referring and you know, providing references. So it's a very, very
political, you know, like how you describe it. And it's interesting because from what you explained to me about you know, your challenges as a barrister and the way it works, it sounds very much like a partner's work in a big law firm. So you're already doing it, you know.
The difference, if I may say, Valeria, of course you do what you are saying. You are saying the partner hands-on, being the chief, being, you know, the responsible of the strategy and so on.
Like someone who
is in charge, But the difference, what I would say compared to partners, is that you are the challenge is quite different because you get not involved in management anymore. You don't have to prepare a budget. You don't have to feed the associates. You don't have to coordinate, you know, a legal team. No, you're alone. So what is different here is pure intellectual challenge, you know. It's resolving and focusing only on legal problems. It's just to construe persuasive arguments and master legal principle. That is only thing that, you know, the barrister are focusing. Also, what is also interesting is that you are independent and autonomous, so you don't answer to anyone. You know, a partner might have to answer to, you know, other colleagues, for instance, in order to, you know, reach your targets, bring the billable work, and so on and so forth. You know, those are political considerations. I don't have any. If I don't want to work, I don't work. The only one who will suffer will be me. But suffer maybe is not perhaps the right word. Is perhaps, you know, I don't need to make 1 million. You know, I might say, you know, I'm enough with what I'm earning today, and I don't need more money because, you know, a barrister is quite lucrative. You know, it's a quite rewarding profession. I would say better than being in a law firm. But at the same time, you know, you can say stop whenever you want.
Yeah.
A law firm, you cannot do that. You have to continue and let the play music, and you know, you need to you know, answer and to work whenever you need it. If I want to take 2 months a year, I'm taking 2 months a year.
Sure. Could you give us a range? I think for like French listeners, it would be interesting.
Yeah.
How much a barrister makes a year? Like, of course, like every year is different, and every barrister is different, and you can moderate. But still, what would you say?
Yeah. So if I have to put some ranges for a junior barrister, would range something between 100 and 200K. For what we call senior junior counsel, which is a mid-level counsel, which I am, is something between 200 and 400K. And for senior counsel, KC, it's at least 500K, and can go to 1 to 3 million. So those are
that sounds like a very profitable position.
Yeah, no, it is. And of course, you know, there is a lot of work to be done. But yeah, those are high level ranges and can go, you know, from one rate to another, depending on the profile, the career, and the amount of time that one will need to put in the business, you know.
So you talked before about the challenges of, you know, the transition from being a lawyer to becoming a barrister, from, you know, running all this organization on your own, and having this pressure of getting clients, also having this pressure of delivering, you know, with excellent legal advice that is judged by your very qualified peers, by solicitors. And at the same time, you mentioned some rewards that come from it. What I picked up is the fact that you're exposed to very different cases, and it's intellectually very rewarding. That you don't have to do any management work, and that you can concentrate on you know, intellectual building a legal argument. And that you are, you know, a master of your time, and that you can regulate the amount of work that you commit to. Is there anything else that maybe comes to your mind as the rewards of the position of a barrister as opposed to a lawyer?
Yeah, what is, I would say, an interesting feature and reward is the prestige and the respect. This is something that is really, really unique. In the role of a barrister is very highly regarded within the legal profession, because it comes with a sense of tradition, respect, and it's why, you know, barristers have this tradition of wearing wigs and gowns in court. And for instance, when I'm you know, having and speaking with solicitors, you are like a god for them. You know, you see partners asking you questions, and they are taking notes of what you are saying. You know, this is quite impressive. You know, and see that is quite something that I needed some time for me to adapt. But it's very rewarding. You know, when you see that people are listening and following you with the advice that you give, it's really, really, for me, it was something very, very nice, and I really appreciate it as part of my barrister role.
That's an interesting angle. I haven't thought of it, but yes, it does sound very, very pleasing, as a position to be someone of authority, even for partners of big law firms, and maybe feel how they regard you and how they need you, and need your expertise on their case.
Indeed, particularly when you have specific profiles of barrister, because very often, and I think again it comes back to being to the niche, if you have someone who that there are only few doing that. For instance, my unique I would say profile is about the fact that I'm civil law and common law trained, that I'm speaking Romanian, French, and English, that I have I'm qualified to appear in front of the Romanian and French courts, but as well in ADGM and DIFC, which is very, very particular to have someone with such a diverse profile. So when they need someone, for instance, I was instructed in a matter before the UK courts, High Court, for a matter which involved a French client, which needed assistance for resisting enforcement of a French judgment in the UK. When you're looking on the market, finding French barristers, there are only very few. So once that you identify the one that you want, that you don't have the luxury to, being picky. And so you need to trust that person. And I think that is also something that you bring to the table, that you have a leverage. It's not the other way around where, when you pitch a general client, when, there will be all the usual suspects, and that very often the difference is made by the price. In some of my cases, the difference is because my culture, my profile, and my past experience, not because I'm the best barrister in England, which I'm sure that there are colleagues much brilliant than me.
But that's very interesting. You really found your, differentiation angles on the market, and you market them well. So when client finds you, probably, or like when solicitors find you, they can see a match between what they need and your profile, and they see the connections. And I think it probably, I guess, took you some work on your profile, on your persona, to find how exactly to translate it to the market so that it is impactful.
No, I think that is right, and perhaps the last topic that we could address is the difference between arbitration and litigation. Because that is something that while I'm very comfortable in arbitration, because I've done that for the last 10 years, over the 10 years, and the role of a barrister is quite traditional in the arbitration. You either come at the advisory stage, before pre-arbitration, and you just give a legal memo on specific legal question. For instance, if you have a contract under English law, you are a French lawyer or a foreign lawyer with no experience or expertise in English law, you ask a barrister, what are my chances of success? So that is the first point, and this is quite standard for any lawyer. The second, standard stage is, helping lawyers to draft submissions, because what the barristers is frequently do is to draft and review legal submission just to ensure that, the work product is persuasive, legally robust, procedurally compliant. But very often people are instructing barristers because they are cheaper. And this is another angle that a barrister will need to factor in. When you have tight budgets, lawyers very often are working in pair with barrister, although, they don't need them perhaps until the hearing, and perhaps not even for the hearing in France, because the lawyers in France, they are doing their own advocacy. Very often, the financial consideration is an added value, because the barristers are charging half of what a solicitor in a US or UK firm will charge. So For me, when I was working at Smith, same experience and profile, I was charging the double of what I'm charging today. So when you tell to the client or your colleagues, guys, now I'm working for half of the price that I was before, that is a game changer. So very often you team up in order to decrease the budget and be competitive and, win those tenders. So you do a sort of package and you work as part of a team. But if not, the third part is, the oral advocacy part, because the barristers are in arbitration, 60 or 70% of the cases brought in at the end, at the hearing stage, just to, work on the opening, closing submissions, to cross-examine witness or experts, and to advocate legal and procedural issues before the arbitral tribunal, because barristers are weekly in court. They have court advocacy skills, and they are much more experienced than, traditional solicitors, because while you might have, I don't know, 3, 4, or 5 arbitration in a year, you might have 50 cases in a court, and you are in court every month, if not every week, for other colleagues. So you can see that their expertise is much deeper than a solicitors we can do. And foreign lawyers and solicitors more often are handling the procedural aspects, such as, managing the strategy, collecting evidence, coordinating with the witnesses, with the clients, managing timeline, liaising with the client and the tribunal, and the barrister is focusing purely on, oral arguments and conducting cross-examination. So those are, the main task in arbitration. However, in litigation, and this is something that I'm always been asked this question: how do you do, when you never appeared in court, you never been in court, you don't know how, an English judge is reacting to your arguments, and how you want to behave, how you need to, what is the etiquette, what are the particularities, indeed, what are the particularities of the court, particularly in England. So in my case, 70% of my work is arbitration work, including arbitrator work. I'm thinking perhaps 2 or 3 cases per year as an arbitrator. But then the 30% remaining is work before the English court, this time as sole counsel. While in arbitration, I can act either with a KC, the hearing, and assisting him or her, and other solicitor colleagues. In court, very often, I'm only with the solicitor, and then I'm preparing all the submissions, the skeleton arguments, attending the hearing myself. No one is doing that. So once you are in the litigation sphere, you need to adapt to the court proceedings. You cannot just translate, the arbitrator experience and say, oh, now I'm a litigator. No, it doesn't work like that. So the first advice, and it's not only advice, it's a requirement under the bar rules, is to respect the strict procedural rules. Under UK litigation, you have to comply with the civil procedural rules, the CPR, and this CPR dictates how cases must progress. If you are not respecting the procedure, the timeline, and everything what is under the CPR, you may be fined, have a cost sanction, or even your case might be struck out. They throw out the case. So that is a big pressure, because you don't know. You have to, ask and learn and see how it works. But at the same time, you need to be sure that you are not doing something wrong, because a cost sanction or having a case being thrown out might have a very, very negative impact on you, including in terms of liability. Yeah. The second, I would say, feature that one needs to be aware is the formality and the tradition. In the UK courts, you need to maintain the traditions and the formalities. For instance, they are using titles, honorific titles, such as when you are addressing to the judge, if you are in the High Court, you have to say, my lord, my lady. As well, wearing robes and wigs in certain courts.
I was going to say, like, do you have a wig?
Yeah, I do have a wig. I do have robes, and those are mandatory before the High Court. So, indeed, those are traditions. Yeah. So one would need not only to respect that by way of courtesy, but also it is mandatory under the CPR rule. So you need to respect that. Another interesting feature compared to arbitration again is that unlike arbitration, which is very often inquisitorial, the litigation before the UK courts is adversarial. What does it mean? Adversarial means that the barrister need to adopt a combative approach, and your focus is to discredit the opposing party's case while presenting your arguments in a very efficient and effective way. So it is you that you bring the proof. It's not for the judge to look for the case. No, it is you that you do all the detective work and put the case in front of the judge. It's very different. As well, the volume of the case law. You know very well that in common law, the main legal source is the case law. So the barristers must be very skilled in researching and applying judicial precedents to support their arguments. What does it mean? It means that not only you need to present the authorities concisely, but also to distinguish them from those which are unfavorable to your case. I.e., why that particular case, is not applying here. So it's very, very different mindset. And lastly, if I may say, is the public hearing. In arbitration, the hearings are private. Yeah. However, UK proceedings are generally public. So this brings an additional pressure because all the eyes are on you. You are the barrister in court. You are sitting in the first stage in front of the judge, and behind you are the solicitors. So everyone is looking at you, and you may have media or public scrutiny. And stressful, it is stressful, and very often those are streamed online. So anyone can see you.
Wow, that's very impressive. Did you already see pictures of you in the media?
I've seen videos of me, and I always said, "Oh, how bad I was," although I won the case, although I was.
That matters.
Sorry.
That's what matters. If you won the case, then
I of course. Apparently, it went well, but for me, I don't know. You can always say, "Oh, I should have, speak louder or less quicker or not gesticulate too much." Every time you learn, But what I can say, and this is something that I will be always grateful to the judiciary, the British judges have been always welcoming me. Of course, they know that I'm not a British standard Cambridge Shakespearean speaker. English is not my mother tongue. But when I always been in court, I felt that I had my place there. I never felt any discrimination on any grounds. I felt that I was welcomed, and the judges always say a very nice word about, junior barristers, how good their arguments were and how the court is pleased about the work that assisted the court to take the decision. So that small comment coming from a judge is always rewarding and gives you more power and energy to say, "Oh, I did the right thing and I made the right decision." And you feel that you are really part of this barrister role that on a first sight one might expect, is something impossible to achieve.
Well, thank you so much, Lucian, for this very insightful and very interesting discussion.
Thank you so much, Valeria. I hope that your audience will be interested in learning more about the barrister life, and I'm sure that if you have to speak again in 5 or 10 years' time, you're gonna see that the trend would be to have more and more solicitors or lawyers moving to the bar for perhaps the same reasons or maybe other reasons that those mentioned today.